4:47 a.m., April 3rd, 2026. Picayune, Mississippi. 14 FBI vehicles moved in a column down a gravel road, headlights off, engines at idle. The convoy stopped 200 meters short of a single-story house at the end of a rural property. No lights inside, no movement. The house belonged to Raymond Earl Cutter, retired. Former Deputy United States Marshal, District of Louisiana, career service. 1988 to 2018. Commendations, 3. Complaints, none on file. The warrant listed 1 count of first-degree murder, 1 count of obstruction of justice, 1 count of witness tampering resulting in death. The estimated age of the victim at time of disappearance, 31 years old. The estimated time between disappearance and this morning's arrest, 9,622 days. 26 years, 4 months, and 11 days. What happened in November 1999 didn't look like a murder. It looked like a cartel retaliation. It looked like a leak from inside witness protection. It looked like one of those cases that federal agencies quietly bury after exhausting every lid. It looked that way for 26 years. Then a retired FBI agent opened a notebook he hadn't touched since 2001 and found a single line he had never put in any official report. That line reopened everything. The witness scheduled to testify was a man federal records identified under the alias Daniel Marchetti. His real name has never been made public. In 1999, he was a mid-level bookkeeper for a New Orleans organized crime operation with documented ties to 3 major narcotics distribution networks operating across the Gulf Coast. He had been in federal witness protection for 14 months. His testimony was considered central to the prosecution's case. Without it, the government's lead count, a RICO conspiracy charge carrying a mandatory minimum of 20 years, would be difficult to sustain. The trial was scheduled to begin November 18, 1999. On November 15, 1999, Marchetti was present at a designated safe house location in the Metairie area outside New Orleans. He had dinner. He made 2 phone calls monitored by the Marshal's service. Both were routine. At 10:22 p.m., the on-duty Marshal noted him as present and secure in the log. By 6:14 a.m. on November 16th, he was gone. No signs of forced entry. No struggle. The bed had been slept in. His personal items remained. His shoes were still beside the door. He walked out. All was walked out. Sometime between 10:22 p.m. and 6:14 a.m. In 8 hours, a federally protected witness in an active organized crime prosecution simply ceased to exist. The initial investigation ran 17 months. The FBI's Organized Crime Task Force in New Orleans pulled the cartel connections. Wiretap intercepts from 3 separate ongoing operations were reviewed for any reference to Marchetti or to the safe house. 14 informants were re-interviewed under pressure. One produced a partial lead that traced to a mid-level cartel enforcer known to operate out of Baton Rouge. That lead went cold within 6 weeks. The working theory that emerged, and eventually calcified into the official record, was this. The safe house location had been compromised. Someone had passed the address, or enough information to identify it, to the cartel. The witness had been removed by operatives connected to the defendants he was scheduled to testify against. Who passed the location was never determined. The internal investigation into the leak ran parallel for 11 months. The US Marshal Service conducted its own review. FBI counterintelligence ran a separate assessment. No source was identified. No disciplinary action was taken against any personnel. The trial collapsed. The lead defendant, a man federal records refer to as Victor Reyes, was convicted on 2 lesser counts and served 7 years. The RICO conspiracy charge was dropped for insufficient evidence. In 2002, a federal judge issued a declaration of death in absentia for the witness. The case was formally closed. The leak investigation was suspended indefinitely. That was the official version. The detail that wasn't in the official version was in a notebook. Special Agent retired Frank Alderman had worked the New Orleans Organized Crime Desk from 1996 to 2003. In 1999, he was one of 4 FBI agents with access to the Marchetti case file and the safe house location. In early 2026, Alderman was drafting a memoir about his years in New Orleans. A private project, never intended for publication, meant to organize his own memory of a complicated career. Going through handwritten notes from the 1999 period, he found an entry from November 14, 1999, 2 days before Marchetti disappeared. The entry described an unscheduled visit to the safe house, not by FBI. By a deputy US Marshal. The Marshal had arrived alone, in a personal vehicle, at 3:15 in the afternoon. Alderman had been doing a routine security sweep of the surrounding block. He saw the marshal enter. The visit lasted approximately 40 minutes. It was not logged in the marshal's service sign-in sheet for that date. Alderman had not reported it at the time. He had assumed it was an informal check-in. Marshals rotated coverage of their protectees. Unscheduled visits happened. He thought nothing of it. He thought nothing of it for 26 years. In January 2026, reading that notebook entry, he called the FBI's cold case unit in Washington. The name of the marshal in his notes, Raymond Earl Cutter. I spent time going through the cold case unit's intake records on this one, and what struck me immediately was the speed of what happened next. This wasn't a slow institutional response. Within 72 hours of Alderman's call, the case was already moving. The cold case analyst who received Alderman's information, a forensic specialist assigned to the Bureau's Civil Rights and Public Corruption Unit, ran Cutter's name through current federal personnel records. Cutter had retired in 2018 after 30 years of continuous service. His record showed no flags, no formal complaints, no disciplinary action of any kind. He was living on a rural property outside Picayune, Mississippi. He received a full federal pension. The analyst cross-referenced Cutter's service file with an open forensic genealogy request that had been sitting in a parallel queue since 2021. In 2021, the National Center for Missing and Exploited Persons had processed a request from the New Orleans FBI field office to re-examine physical evidence from the 1999 Safe House case. The original evidence inventory had included a partial fingerprint lifted from a window frame at the back of the Safe House property, not the front entry, not the main access points. A window frame on the exterior of a utility shed, 20 meters from the main structure. The print had never been matched in 1999. The latent print databases in 1999 were limited. The print sat in storage for 22 years. When forensic genealogy techniques advanced sufficiently, the New Orleans office submitted a re-examination request. The 2021 submission went into a backlog queue. It was still pending when Alderman's call came in January 2026. The cold case analyst flagged the connection. An expedited review was requested. 6 days after Alderman's call, the forensic genealogy unit returned a result. The partial fingerprint from the utility shed window frame matched Raymond Earl Cutter's service file. Not a match to Cutter as a responding officer. Not a match to Cutter as part of any documented visit to the property. A match with no corresponding log entry. No corresponding report. No documented reason for Raymond Earl Cutter's fingerprint to be on the exterior window frame of a utility shed at the back of a federal witness protection safe house in the dark hours before or after the last documented contact with Daniel Marchetti. The FBI's Civil Rights and Public Corruption Unit opened a formal investigation on February 7th, 2026. Here's what I find genuinely strange about this case. It's not that a federal marshal was suspected of betraying a witness. Corruption inside law enforcement exists. History documents it. What's strange is the specific shape of it. That a man could spend 30 more years in federal service, retire with commendations, collect a government pension, and remain entirely undetected while the body of the man he was responsible for protecting lay somewhere on American soil. The investigation needed to answer two things. Not just who, but how. How does a deputy US Marshal remove a federally protected witness from a safe house without triggering any alarm, without leaving any documented trace, and then return to duty the following morning as though nothing had occurred? The answer, as the investigation developed, involved a level of operational knowledge that only someone inside the Marshal Service would possess. The 6-week investigation that followed February 7th involved 3 primary components: financial forensics, electronic surveillance, and witness interviews. Financial forensics came first. Investigators examined Cutter's financial records going back to 1998. What they found was not a dramatic windfall. There was no sudden unexplained deposit in late 1999. No offshore account. No large cash purchase. What there was, starting in January 2000 and continuing at irregular intervals through approximately 2009, was a series of structured cash deposits, each below $10,000, none triggering automatic bank reporting thresholds, that in aggregate totaled $214,000 over 9 years. The deposits were irregular in timing and amount. They came in roughly quarterly, sometimes less frequently. They averaged $5,800 each. They stopped entirely in 2009. On their own, the deposits were not conclusive. Many explanations existed for a working federal employee receiving supplemental income. But in the context of the fingerprint evidence and the timeline, they established a financial pattern consistent with payment for services rendered. Wiretap authorization was granted on February 19, 2026, after a federal judge reviewed the fingerprint evidence and the financial analysis. Cutter's communications were monitored for 3 weeks. In that period, 2 calls stood out. The first was a call Cutter made on February 24th to a number registered to a man in Biloxi, Mississippi. The call lasted 11 minutes. The conversation was oblique. References to a property matter, a concern about paperwork, an old arrangement that Cutter said he didn't want reopened. The man in Biloxi, whose name federal records in the case file redact, had no documented connection to Cutter's federal career. Financial analysis later showed the Biloxi number was associated with a now-defunct logistics company that had operated in the Gulf Coast area from 1997 to 2011. The second call came on March 2nd. Cutter called a number that traced to a disconnected landline in Jefferson Parish, Louisiana, the parish that includes Metairie, the area where the 1999 safe house had been located. The call went unanswered. Cutter tried the same number twice more over the following 3 days. No answer any of the 3 times. Neither call produced a confession. Neither call was admissible as direct evidence of the 1999 crime. But both calls, documented and preserved, established that Cutter was actively managing old connections in the weeks after Alderman's cold case tip, suggesting he was either aware that scrutiny had returned to the 1999 case or was taking precautionary steps for reasons of his own. Witness interviews added a third layer. The FBI located 4 individuals who had been connected to the 1999 trial or the safe house operation and were still alive and reachable in early 2026. The first was a former Marshal Service dispatcher who had worked the New Orleans district in 1999. She had retired in 2011. She told investigators that in the weeks before Marchetti's disappearance, she had received an informal verbal request, not a documented work order, not an official assignment, from someone she identified as a senior deputy marshal to provide the daily security rotation schedule for the Metairie safe house location. She had provided it. She had assumed it was a routine coordination request. The senior deputy marshal she described matched Cutter's physical description and service assignment for that period, though she could not make a definitive identification after 26 years. The second was a former organised crime defence attorney who had represented one of the minor defendants in the 1999 trial. He declined to provide specifics, but confirmed, in a recorded interview, that before the trial collapsed, he had been told by his client that the cartel's reach inside federal law enforcement was deeper than the FBI's investigation had assumed. He stated this was not specific to any individual and that he had reported nothing at the time because his client's information was hearsay and had come in the context of plea negotiation. The third was a surviving federal agent who had been part of the original safe house security rotation in 1999. He told investigators something specific. On the morning of November 16, 1999, when the disappearance was discovered, the first call to the duty desk had not come from the on-site marshal. It had come from Cutter, who was not assigned to the safe house that day. Cutter had called in, before the morning check-in was due, to ask whether there had been any issues overnight. The on-duty marshal, not yet aware that Marchetti was missing, said everything was quiet. Cutter had then said he would be out of contact for a few hours and ended the call. The former agent had included none of this in his 1999 report. He said he had not been asked about it directly and had not thought to volunteer it. Asked why he was providing it now, he said he had been waiting for someone to ask the right question for a long time. The fourth was an individual who had been a junior Marshal Service employee in the New Orleans district in 1999. His testimony was limited in scope, but added one specific piece of information. In early November 1999, approximately 2 weeks before the disappearance, Cutter had asked him casually whether the safe house property had any outbuildings, sheds, storage structures, and whether they were typically included in the security suite perimeter. The junior employee had told him yes, there was a utility shed, and no, it was generally outside the primary security sweep zone. That conversation, if the testimony was accurate, placed Cutter's interest in the exterior shed, the location where his fingerprint was later found, before the night of the disappearance. Here's the take that will probably generate disagreement. The system failure in this case was not Raymond Earl Cutter. One corrupt individual inside a large agency is a management problem, not a systemic one. The failure was the 17-month internal investigation in 1999 and 2000 that never developed a single person of interest from inside the Marshal Service itself. The working assumption was external compromise. The possibility that the leak was internal, that the person who provided the safe house location was someone with authorized access, was apparently never pursued with the same intensity. That's not Cutter's failure. That's institutional. What do you think? Did the review process in 1999 fail because investigators were genuinely blind to the possibility? Or because pursuing internal corruption in a federal agency is something the agencies themselves are constitutionally reluctant to do? Leave that in the comments. By mid-March 2026, the investigation had enough to present to a grand jury. The fingerprint evidence, the financial deposits, the dispatcher's testimony about the rotation schedule request, the former agent's account of Cutter's early morning call, and the junior employee's account of the conversation about the utility shed combined into a circumstantial case that the Civil Rights and Public Corruption Unit considered sufficient for indictment. But there was one component still missing. The body of Daniel Marchetti had never been found. Without physical remains, the murder charge depended entirely on circumstantial evidence and the in absentia declaration of death from 2002. Prosecutors could make the case, but the absence of physical evidence was a vulnerability. On March 17, 2026, a federal judge signed a search warrant for Cutter's rural property in Picayune. The search was not immediately executed. The decision was made to surveil the property first, to observe whether Cutter's behaviour changed in the days following the wiretap activity, and whether he might take any action that would provide additional evidence. A fixed surveillance post was established. A rotating team of 4 agents maintained observation around the clock. For 11 days, nothing unusual occurred. Cutter left the property twice, once to purchase supplies at a rural hardware store, once to attend a church service in the town. Both trips were followed. Neither produced anything of evidentiary value. On the 12th day, March 29, 2026, at approximately 7:30 in the evening, surveillance observed Cutter spend approximately 90 minutes in the area behind his outbuilding, a large wooden structure at the rear of his property, roughly 40 metres from the main house. He did not appear to be performing routine maintenance. He spent time near a section of ground adjacent to the structure's north wall. He used a long-handled tool, consistent with a shovel, for a portion of that time. Surveillance documented the activity with photographs and video. On April 2, 2026, the Civil Rights and Public Corruption Unit requested an expedited grand jury session. The session took place the same afternoon. Indictments were returned at 6:14 p.m. on April 2, 2026. The arrest was scheduled for 4:47 a.m. the following morning. One detail that stuck with investigators reviewing the surveillance footage later: Cutter returned to the outbuilding area twice more after the initial March 29th activity. Once on the 31st, briefly, and once on April 1st, for approximately 20 minutes. The investigators watching the footage noted that his pace was unhurried. His demeanour was consistent across all 3 observations. Whatever he was doing at the back of that property, he did not appear to be panicking. Whether that spoke to composure or to something else was a matter the prosecution would eventually have to interpret for a jury. At 4:47 a.m. on April 3, 2026, 14 federal vehicles moved in a column down the gravel road. The entry team, 9 agents in tactical gear, moved from the vehicles to the perimeter of the house in under 90 seconds. A secondary team of 5 positioned at the rear of the property to secure the outbuilding and the ground adjacent to it. 2 additional agents remained with the vehicles to manage communications. At 4:51 a.m., the entry team announced federal agents at the front door. There was a 17-second pause. Then the door opened. Raymond Earl Cutter, 61 years old, in a bathrobe, opened his front door and looked at the agents on his porch without visible expression. He asked if he could get his shoes. He was told he could not. He was placed in custody at 4:52 a.m. He made no statement. He did not resist. He asked, once, as he was being walked to a vehicle, whether he was allowed to call a lawyer. He was told yes. He said nothing more. The search of the property began at 5:03 a.m. The outbuilding yielded evidence immediately. Behind the north wall, in the area where surveillance had observed Cutter's activity, investigators located a section of disturbed earth consistent with multiple excavations over a long period. Ground-penetrating radar equipment, brought specifically for this possibility, identified a subsurface anomaly at approximately 1.4 metres depth. Manual excavation began at 6:47 a.m. At 9:23 a.m., investigators located human remains. The remains were skeletal, consistent with a burial of at least 2 decades. A forensic anthropologist on site assessed the condition and estimated time of interment at 20 to 28 years, consistent with 1999. Dental records from the Marchetti case file, still on file with the US Marshal Service, were transmitted to the on-site forensic team by 11 a.m. A preliminary comparison was conducted. The remains were consistent with the dental profile on file. Formal identification was completed by a forensic odontologist at the FBI laboratory in Quantico 6 days later, on April 9, 2026. The remains were those of Daniel Marchetti. He had been in that ground for 26 years, 400 meters from the living quarters of the man who had put him there. Raymond Earl Cutter was formally charged on April 3, 2026, with first-degree murder, obstruction of justice, and witness tampering resulting in death. He entered a not guilty plea at his arraignment on April 11, 2026. Trial was scheduled for January 2027. His federal pension was suspended pending the outcome of criminal proceedings. The murder charge, because the death occurred in the course of interference with a federal witness, carried eligibility for the death penalty under federal statute. The Department of Justice had not publicly confirmed by the time of this reporting whether it would seek capital punishment. The biloxy contact. The man Cutter had called on February 24th, was interviewed by investigators in April 2026. He invoked his Fifth Amendment right against self-incrimination and retained counsel. No charges had been filed against him as of the time of these events. The 1999 organised crime trial that Marchetti's disappearance had derailed was not being reopened. The principal defendant, Victor Reyes, had died in 2017. The organisation he had led had fragmented in the years following his conviction. Most of the other defendants had completed their sentences. The evidence Marchetti had been prepared to provide, his testimony, his documents, his first-hand account of the financial infrastructure he had maintained for the organisation, died with him in November 1999. It could not be reconstructed. The cases it might have built would not be built now. Frank Alderman, the retired FBI agent whose notebook entry reopened the case, was interviewed after the arrest. He said he had carried the image of that unscheduled visit for years without understanding its significance. He said he wasn't sure he fully understood it even now. Think about his position for a moment. A detail observed. A detail not reported. Not out of corruption. Not out of complicity. Out of the ordinary human tendency to interpret what we see through the most innocent available framework. He saw a colleague enter a building and leave. That was all. The framework that would have made the detail significant didn't exist yet. Wouldn't exist for 26 years. How many other details exist in how many other notebooks from that era, unread and uncategorized, waiting for a framework that hasn't arrived yet? The FBI's Civil Rights and Public Corruption Unit stated after the arrest that the Cutter case had prompted a review of internal protocols for investigating suspected leaks in witness protection cases. The review was ongoing. No specific changes to procedure had been publicly announced. Here's what this case tells us about the system. Witness protection depends on the integrity of the individuals who implement it. The physical security is real. The procedural layers are real. But at the operational level, the system is only as secure as the people inside it. Raymond Earl Cutter was not a rogue actor inserted from outside. He was a man who passed every screening, served for 30 years, and used the access that institutional trust gave him to do something that institutional trust was specifically designed to prevent. The warrant that was never closed. The question of how Marchetti disappeared was answered on April 9, 2026, when dental records confirmed what the ground had preserved. The question of what else may have been compromised during Cutter's 30-year career, and by whom else, and in exchange for what, remains open. The Biloxi contact has said nothing. The disconnected Jefferson Parish number has never been traced to an active individual. The financial deposits between 2000 and 2009 came from an account that no longer exists, at a bank that merged and restructured twice in the intervening decades. The money trail ends at a wall. Somewhere behind that wall, at least one more person knows what happened in November 1999. Whether that person is still alive, and whether they will ever be identified, is not something the current investigation has answered. If you've followed similar cold case reopenings, you know how this pattern tends to unfold. Comment why yes if you think the Biloxi contact eventually cooperates, or no if this is where the trail ends. Based on what we know about how these cases close, we have a clear read on that. If you want that analysis, subscribe and check the next upload. The case is open. The warrant was served. What Cutter built for himself. A quiet retirement on a rural property, a government pension, 30 years of institutional respectability, was built on ground that had been disturbed once and then left undisturbed for more than a quarter century. The ground held what it held, until someone asked the right question.